Sorry for being late.
No, no.
Yes.
Have to mention item number 2, my lord. Today, my lord, we have some difficulties, my lord. My lord.
What
Only
difficult? Huh?
one week, my lord. My lord, we could not trace out the file, my lord, in December. Only 1 week, my lord. Here,
I have also no objection. NI.
Enact.
Hmm.
Enact, no objection. Against conviction.
no, my lord, against award of 1,50,000 rupees. Conviction.
This, but it will go to December. No date in between. Ashwini? 5th of December.
Yeah, please, your lordship, I beg to mention item number 3. I am for the respondent. Due to personal difficulties, the engaged counsel unable to proceed the matter to the lordship.
Okay, 5th December.
Much obliged.
May it please your lordship. Lordship, I beg to mention one item, lordship, for listing on Monday, lordship, for withdrawal, review petition.
Review
Review petition, lordship.
by this order was by this court.
Yes, lordship.
Which matter?
Priyanka, lordship, item review petition number 165/2024. Lordship,
WBC read petition.
read petition, lordship.
Okay. Anyway, allowed. Review since it will have to come to me. Give the list. Yes.
Judgment. Well, my lord, in fact, what had happened there is Supreme Court cases straight away on this point is because, my lord, 323 1-year imprisonment, my lord, hardly there is any case goes to Supreme Court. Because by the time Supreme Court decides an appeal, my lord, 1-year term is already gone. So, my lord, I could lay my hands on 2 judgments. One judgment I found very interesting, my lord, that 1988 judgment, my lord. That is also 323. And then, my lord, though the conviction was sustained, my lord, but he was eventually released on the Probation of Offenders Act, my lord, with a rider that the accused would be deemed to have been released under the Probation of Offenders Act. 3 months imprisonment, same 325 converted into 323, 323 sustained, and then because the incident that 1987 SCC online Guwahati 25. My lord will see the last paragraph, para 8.
Just that is 87 judgment.
Yes, yes.
Paragraph
8. That is
There is-
something, my lord, in fact.
Okay. Okay, we'll allow this petition. There are inconsistencies. In fact, if we go deep inside, it's a case of acquittal. But since he has said that, okay, this he'll have
My submission,
he'll happy with this. We'll do that.
And one thing, your lordship will take appellant number petitioner number 1 expired. That the date of should I give the
Yes,
date?
yes, of course.
Petition ka copy.
But we'll get this order maybe Tuesday. Not date.
I lost contact with the client for last 10 years probably. Date to be petition ka? Yes, yes. 4/11/2011.
Petition number 1.
Petition number 1.
Mona.
Mona, Morile.
Yes, dispose of.
Please, your lordship. This mirror can be taken at 2 p.m. lordship.
Release this matter on 5th.
Of like
No, 2 is already.
Lordship, for the timing, Lordship, TJ Mohan.
No timing today, on 5th. Yes, Talukdar, which is your item? 9. Why this is listed in?
Six months. Six.
Elcher is, Zia, Elcher is received. Huh? Scan copy, it is there. This matter, let this matter be listed in admission column on give a date. As parties, as it is ready as regards service and record. Huh? If none appears, we'll proceed with the scan copies at this. When? Oh, this admissions matter we can listen before that also. November 21st of May. That hearing matters only that in that way we are fixing. Admission, we adding 2 matters will not make a difference. Yes, next.
7.
Item number 7, my lord, I may be allowed to withdraw. My lord.
Huh?
I may be allowed to withdraw. No, appellant expert,
Okay,
no petitioner. I am the petitioner, my lord. In this.
okay. The learned counsel for the petitioner submits that he has instruction to withdraw this present
That is appellant expired long back, my lord.
criminal evidence petition in as much as the appellant has expired long back. Full stop. In view of the aforesaid, matter stands closed.
Yes.
8.
None appears for the petitioner on call. The present petition, though Mr. Swenson, learned Swenson. Present petition is filed under section 401, read with section 397 and 482 of the Criminal Procedure Code 1973, assailing judgment and order dated 24/7/2014, passed by the Principal Judge, Family Court, Kachar, Silchar, in FC Criminal 138/2013, whereby a maintenance of rupees 3,000 was awarded to the awarded in favor of the respondent to be paid by the petitioner herein. And for the minor daughter of the parties for rupees 6,000 मिला दिए थे. ठीक है सर. LCRC. First, the material available on record. It is available on material record. Also seen the also peruse the judgment passed by the learned principal. Just full stop. From the perusal of the material available on record, it is seen that the parties contested the proceeding and adduce evidence in support of their claim. Full stop. The present appellant also adduce one witness, DW1. Full stop. After framing point of determination, the learned court below considered the evidence of the witnesses as well as the materials evidence adduced by the parties. Full stop. And concluded that that the wife and the daughter are having no sufficient means to maintain themselves, and that the present appellant has refused / neglected to maintain the wife and her wife and his minor daughter having sufficient means, and at the same time it is also concluded, considering the material evidence, that the wife was unable to maintain herself and her minor daughter. Full stop. While coming to such conclusion, the learned trial court below elaborately dealt with the evidence of PW1, the wife, PW2, one relative of PW1, and concluded that their evidence remained unshaken during the cross-examination, and the parties is able to establish the aforesaid point. Full stop. While considering the evidence of DW1 and DW2, the learned trial court concluded that through the evidence of the DWs, it is established that that there are certain disputes, between the families, and a suit for restitution of conjugal right was also filed. Full stop. And that the DW2 and DW3 tried to persuade the parties. And thereafter, the court also considered that though the court, on the basis of such evidence, concluded that the parties had started living separately. However, that is not willful on the part of the respondent wife. It is also a conclusion of the learned trial court, after consideration of evidence of PWs, that the defense has failed to elicit anything from the witnesses. Full stop. Thereafter, the aforesaid conclusion was arrived at. While doing so, full stop. After perusal, and accordingly, the award was maintenance was awarded. Full stop. While considering the quantum of maintenance, the learned trial court below also took note of the monthly income of the petitioner, that is rupees 23,000 per month, and his net income of 21,024, which was admitted during the course of the evidence, course of cross examination. And therefore, according to the learned trial court, an amount of rupees 3,000 and so and so Agaji to 6,000 shall be a reasonable amount for maintenance. First of, after perusal of the aforesaid material and the judgment, this court is of the view that the conclusion arrived at by the learned trial court cannot be held to be illegal or without jurisdiction, or there is any perversity in this matter. First of, the evidence so discussed on the basis of evidence, the conclusion arrived at on the basis of the evidence cannot be said to be a conclusion which a reasonable man would not have arrived at on the basis of the material evidence available on record. That being the position, this court is not inclined to exercise its revisional jurisdiction to interfere with such an well-written decision. Accordingly, the present petitions dismissed, interim order, if any, stands vacated. Yes, Mr. Talukdar, what is this?
Appeal and acquittal law. So we have taken steps. Or Lordship, kindly see the office note dated 19/9/24. Whereby they have received the.
Received?
The
Where is
ID
it?
card has also been returned back.
Okay. This is IA is for leave.
IS for leave.
Leave.
Actually, what happened in
Leave-
trial court,
Hmm.
convicted. Then they preferred appeal, it was allowed.
Allowed.
So then we have come.
So therefore,
So
leave is
leave may be granted.
leave will grant a leave. Hmm. Hard. Mr. Talukdar, learned counsel for the petition. The present application is filed under sections 378 within bracket 3 CRPC for grant of leave to prefer an appeal against the judgment and order dated 21/8/2019 passed by the learned session judge Dorong Mongoldoi in criminal appeal number 17 within bracket D-2/2017, whereby the respondent number 1 was acquitted from the charge under section 138 of the Negotiable Instrument Act. First up, this court, under its order dated 5/2/2020, already issued notice to the respondent number 1, which has duly been served as reflected in office note dated 19/9/2024. However, none appears for the respondent on call. Accordingly, first up, perused the ground detailed in this application for grant of leave, also perused the impugned judgment and order. After perusal of the same, this court is of the view that the petitioner have been able to make out a case where this court should grant leave to appeal. First up, accordingly, the present application stands allowed by granting leave to the petitioner to prefer the appeal against judgment Swencho. First up, the connected appeal be registered and be listed before
For
the
admission.
listed for admission. First up, IS stands disposed of.
Much.
Yes.
In this case, what happened in this case, Lordship?
Hmm.
I filed this criminal petition
Hmm.
in the month of January 2019, Lord.
Hmm.
And on 1/7/2000, Lordship, 2021, charge sheet was submitted, Lord.
Hmm.
Thereafter, I filed this IA
Hmm.
or amendment of this cost title of this Lordship criminal petition.
Where is the IA? This is IA, na? 24. heard Mr. Censor, learned counsel for the petitioner. The present application is filed for amendment of the cause title of the connected criminal petition being connected criminal petition registered as criminal petition number 1408/2019. By filing the aforesaid application, under section connected under section 482 CRPC, the petitioner has assailed the FIR registered as you have come for quashment of FIR, is not it?
Yes.
FIR
7/11/20.
Huh?
7/11/2007.
Where do you get it?
19.
Huh? Page.
Page of first page, Lordship. First title, Lordship. In my criminal petition, Lordship. Of quashing of FIR data 7/11/2019, Lordship.
First title of your
Main petition, Lordship, my criminal petition.
okay, that quashing of FIR registered as Tezpur PS case number 2163/2019 under section 494/294/506 IPC. Full stop. It is the case of the petitioner that during pendency of this petition already search sheet has been filed, is not it?
Yes, Lordship.
Search sheet has been filed by the investigating authority, and therefore he would like to challenge the aforesaid search sheet. Therefore, the petitioner would like to incorporate the challenge to the search sheet in this present proceeding. Accordingly, the present application is filed. In the connected proceeding, accordingly, the present application is filed. Peruse the materials available on record. In the considered opinion of this court, such prayer is required to be allowed. Accordingly, same stands allowed. Full stop. The learned counsel shall furnish an amended cause title to the learned counsels representing the respondents within a period of
2 weeks, Lordship.
what 2 weeks? Is there any stay? You already
Stay
search
there.
sheet file. What stay?
Earlier stay is there.
Forget it. Then search sheet file, what stay? Huh? Within a period of 10 days from today, and thereafter the registry and also a copy with a copy to the learned counsel for the learned counsel representing the respondents. Yes. Yes, Mohanta.
My lord, and code number 1, my lord, item number 5. 5, my lord, already adjourned, my lord, no problem.